Welcome to Divorce Talk, a podcast for people who are contemplating divorce, going through one, or would like to know everything about the divorce process. Each episode, you'll hear from Chicago divorce lawyers from Beermann LLP, one of the largest divorce and family law firms in the state of Illinois, speak on all things divorce, from child custody, divorce litigation, mediation, the collaborative process, and everything in between. Now, here are your hosts, the Beermann Divorce Lawyers.
Hello, welcome to the podcast. I'm Sandra Napoli-Diarco. I'm here with Tom Field and Jessica Boike. Today we're speaking about experts employed by divorce lawyers during this process. So without further ado, Tom, Jessica, I know you both have done podcasts before, but for people who haven't listened to your previous ones, why don't you tell us a little bit about yourselves?
I'm Jessica Boike. I've been practicing for over 12 years. I'm a partner at the Beermann firm. I live in the suburbs with my husband, 2 kids, and 2 dogs.
Tom Field. I am partner here, head of the family law department, and been practicing in this area of domestic relations for about 17 years, and live in the city with my wife and 2 kids. And let's talk divorce.
Let's talk divorce. So who are the experts that you and your clients rely on during the divorce process?
Sure. So Jessica was kind enough to help me assemble a laundry list of all the people that we tend to work with on a fairly routine basis in our jobs. By way of background, so when we enter a divorce case, in particular, there are varying issues that we're dealing with. And if we split it in half, so to speak, half of the issues, assuming there are children involved, are parental and child related, and the other half are financial. So what we've got assembled to talk about today are the varying types of third parties outside of our firm, who are non-lawyers mostly, but some are other lawyers, who we and our clients rely on to help get through this process, to address various issues. So I think, it probably helps to start with the issues and who we may encounter. Thinking about today's podcast, I think I said to Sandra that, a hypothetical case may be kind of a good way to think about how these issues come about. So for purposes of today, and Jessica can feel free to disagree or interject, but, I think we should probably talk about a case where we've got a couple that's been married for, maybe 15 years. One of the spouses has a closely held business, and they've got 2 children, and wife has been a stay-at-home parent. Let's start out with those general parameters.
Sounds good.
And you want to dig in on maybe financial experts. Why don't we start there?
Right. So in a case like this, there's certain issues that immediately pop out for us to be able to resolve the case, either via an agreement, which is always preferred, or in court at a trial. And so one of the examples that Tom had just outlined in his hypothetical is, let's say the husband has a closely held business. Well, what is it worth? We are divorce attorneys. Though we have a lot of experience and practice in dealing with closely held companies, we are not valuation experts. And so in order to have a number assigned to that business, we pull in one of the professionals that we utilize often to essentially do an analysis of that closely held business and to determine the value of it. Depending on how big it is, there are different professionals that we can utilize. Sometimes people want a summary opinion, and you can reach out to an accountant and a CPA. They can look at the cash flow or whatnot and give you a rough idea of what that closely held company is worth. And if both parties have participated in that business or have an understanding of it, that might be enough for purposes of settling the case. But when you're going to trial and there's a disparity in what you believe the value of that business is and what your opponent believes, you need somebody who's accredited with the specific certifications and degrees in order to come in, forensically look at all of the cash flow, the personal expenses that are being paid on the owner's behalf, the different equipment that might be utilized and whatnot, and be able to provide a professional opinion in court that withstands scrutiny as it relates to that value. And so we tend to use people who are certified to do business valuations to come in and provide us an idea of what that business is worth. A lot of the times, both sides will hire one independently and compare those two values, or sometimes people use a joint expert. Luckily, there's a few very reputable people that we've utilized where other firms have utilized them as well, and we trust in what their work product is. But that's one person that, especially in this hypothetical, that we would use, and whether for settlement or for trial.
So sticking with the same hypothetical, and whether it's the same expert that would do valuation or not, as some do both, we will often rely on an expert to help us do a cash flow analysis. So when you've got a closely held business, there are often times where it is difficult for us as lawyers and our clients to ascertain exactly what the other spouse's income is. We can't just rely on tax returns to tell the whole story. So in this example where you've got a closely held business, some questions arise as to, well, a lot of people with closely held businesses, they fudge a little bit. No big deal, but they're paying some personal expenses out of the business. So the business may be paying for the cell phones for both of the parties and their children. It may be paying for insurance. It may be paying for gas. I've even seen instances where business have paid college tuitions for children and things of that nature, or vacations for the family. Those end up being add backs. So sometimes it's necessary to have an expert come in, give them credit card statements and the general ledger, which is basically the check register for the business, and say, review this, ask questions as necessary, help us distill down what the actual income is. Another issue that comes into play is a lot of times there are retained earnings in a business and people are distributing out money or not, as the case may be, even though it may be available. But if it's an S corporation, by way of example, taxes flow through to the person who is the partner in that corporation or the owner in that corporation. So the marital estate may be paying taxes on money that it's not actually receiving because the business is hanging on to some of the money to operate, but sometimes it's more than the business needs to operate. So that's another example of an expert who is usually almost always a CPA. Some of the business valuation experts we use double as cash flow experts, so that we don't have to have multiple experts in the same case. But that would be another example of work that we would send out of house for the benefit of a client or to ascertain the income of a spouse.
That makes sense. And the information is given to the divorce lawyers, and then you obviously analyze it and review it with your clients, correct?
Correct.
It doesn't go to the client and so forth.
Keep in mind, when any of the financial issues that we're talking about today, the goal in every divorce case is really twofold. It's to nail down a balance sheet of all of the assets and liabilities in the case, and at the same time ascertain what the cash flows are. Because you need to have an agreement on asset and liability values as well as incomes for purposes of being able to divide the assets and set support obligations. So those are really the two goals that we're trying to get to in each case.
I'm sure it becomes very difficult when you have someone who has a private family business, and maybe they're showing they make $10,000 a year when in reality it might be
$1 million
lot.
lifestyle.
Right.
Absolutely. And it's not rare that we see those. It's with some level of frequency. Jess, do you want to talk about maybe vocational experts, as long as we're talking about income?
Yes. So for purposes of determining cash flow of the primary wage earner, Tom had just indicated that sometimes we need cash flow analyses. However, in this hypothetical, the stay-at-home mom, if she had previously been working in a profession for the first, let's say, 10 years of the party's marriage, 15-year marriage, and just the last 5 years she's been out of the workforce, she does have income earning abilities such that it should at least be considered when setting support. Now, it's not to suggest that she can go back into the workforce as if she was in year 10 and earn the same amount. So what do? Well, there are professionals who are called vocational experts, and they come in and they essentially do a market analysis of what could that person earn in light of her professional accreditations, her education, the fact that she has been out of the workforce for 5 years. Is there any additional certifications, credits, lessons, classes, or whatnot that she'd have to take to recertify in a certain profession, or to just essentially gain back those skills that may have been lost over the last 5 years, or even just catch up on the tech that's being used in certain firms or whatnot. And so that vocational expert looks at all of that information and then generally assesses if this person did A, B, and C, she could earn X number of dollars in 1 to 2 years. And it's information that the courts really like to be able to review and rely on when setting maintenance and support, because you sometimes have the primary wage earner saying this person is not a maintenance candidate or doesn't need child support because they can go back in the workforce tomorrow and earn based upon their historical earnings. And the other side says, I can never make any more money because I've been out of the workforce for 5 years. This person comes in and says, Judge, here's the reality of the situation. There's no way that she might be able to earn what she did when she left the workforce, but she does have income earning capabilities, and here's what they are. Also, it's helpful because that vocational expert can set out the different steps that person might have to take in order to get herself back in the position she once was, which is helpful for both parties involved. And so that is sometimes we rely on that expert to come in and give us a dollar amount, or at least to demonstrate that there is income earning capabilities. It is then up to us at trial or in a settlement as to whether or not we'll be seeking an imputation of that income to that party. So, for example, if the vocational expert says this person could make $50,000 if she started tomorrow, we would ask then in settlement that at least be considered as an offset to some degree on any support, and at trial that it be considered when calculating support in both maintenance and child support.
So along the lines of accountants and support, another thing that we do sometimes that people would be unfamiliar with that aren't in our world is hire an expert to do a lifestyle evaluation for us. And this is typically conducted by a CPA, although there are some bookkeepers that are fairly expert in doing this and have been given the expert title by judges and qualified as experts. This is essentially a bookkeeping function with some nuance. So most of our clients here at Beermann are affluent and have, varying levels of substantial lifestyles. What comes along with that is typically a high level of income. Well, our statutes that we've got for support in Illinois have guidelines, but the guidelines phase out over $500,000 of income. And so we as lawyers, especially lawyers who have a clientele that typically has a level of income that phases them out of the typical statute, have to take a little bit of a deeper dive and say, all right, well, should we extrapolate based on the guidelines to whatever the income is? Or should we be doing more of a needs-based analysis? as far as maintenance, which is our term for alimony. And a lot of times in more significant cases, we'll look more towards that needs-based analysis, because if we were to use the guidelines, it would provide for a level of support that would be far and away exceeding what the actual lifestyle was during the marriage. And our statute says, the intent of the Maintenance Act is to afford the recipient spouse the ability to maintain some semblance of the same lifestyle similar to that which they enjoyed during the marriage. So these lifestyle experts come in and essentially take what we consider a financial affidavit, which has all of the expenses of a household on a monthly basis, broken down into very detailed categories: your mortgage, your real estate taxes, your homeowner's insurance, your utilities, etc. For both parties, all households involved, all of their children, and breaks it down into the individuals as best as they can. So for using our present hypothetical, if the wife was seeking maintenance from the husband, the vocation or the lifestyle expert would try as best they can to work with the wife, if they were the wife's expert, to review all of the bank records and credit card records for a period of time. I would say a standard period might be the 3 years leading up to the marriage or the divorce, and try to ascertain as best they can what the wife's expenses were on a monthly and annual basis, so that you can justify a maintenance request for settlement purposes. Sometimes those experts also come and testify at trial if the matter remains contested. But that would be another example of an income and expense type of expert that we would hire for one of our cases.
Mm-hmm. Interesting. What else? Who else do you hire?
I was just saying, going back to the closely held business, we discussed value and we discussed cash flow, but there's also one other component is classification of that business as non-marital or marital. And so at times we hire experts to actually help us trace out different transactions to figure out if a piece is marital or non-marital. The reason why that's important is because if that is a non-marital asset, though the valuation is still important into consideration at trial and settlement, it is not to be allocated between the parties. The person who owns the non-marital asset will be awarded said asset. Now, the income generated from that is a different story, but we have hired in the past different people to go through corporate books, certificate shares, bank account statements, et cetera, going in and out. And sometimes it's the business valuation person, someone from their office who can do it forensically, but otherwise it could be even yet another professional that's brought in to ascertain whether or not there's certain pieces that are subject to classification issues.
And as Jessica said, it's typically a forensic accountant that'll come in and help us with
Right.
those. But if we go back again to our hypothetical, if the husband had acquired any portion of that business interest in the closely held company prior to the date of the marriage, there's likely a non-marital component unless he somehow commingled it with any additionally acquired shares in the business after the date of the marriage. But that's something that the records don't always easily bear out. And those forensic experts will come in, and it doesn't even necessarily have to be a business. It can be investment accounts. It could be actual investments in other business interests or privately held investments like private equity. So those forensic accountants will often come in and help trace out to the best of their ability based on records that are available, so that they can help us with characterization issues. So if we shift to property,
Mm-hmm.
If we're talking real property, we're talking about ascribing values to real estate. And that's something that is commonly done in our cases. I would say probably 90% of the time, we're hiring a real estate appraiser to come in and put a value on whether it's personal real estate or business real estate, so that we can accurately assess that value on a balance sheet. I don't know that there's more that we need to necessarily say about those particular experts, other than the ones that we tend to use are well credentialed and have experience testifying in court in the event that we need them.
And just to recap, Jessica, did you say that both parties will hire experts? So if if the wife's attorney hires a real estate appraiser, does the husband's attorney also hire one?
So it depends. You can hire one jointly with the option that if one of the parties does not like that value, that they can go hire their own, at which time, if that value comes in higher or lower than the other person, then they'll want the option to have their own. There's times where people will say, we're doing a joint appraiser and we're agreeing that it's binding, and so one and done, and that's all. And then there's the circumstances where each of them get their own. And if they're close enough, you average the values. If they're too far, sometimes you get a third expert to come in again, and you average either all three or you average the two appraisals that are the closest, et cetera. So there's a myriad of ways of doing it. Obviously, the more appraisals you have, the more cost it is. And so one of the other professionals that we lean on, I don't know if you would call them experts because they can't necessarily testify in all circumstances to value at trial, but who are very helpful to us, or even real estate agents. So they can't testify to what the value is, but they can give you insight into what the market looks like and what other properties have been selling for in the neighboring communities and whatnot. And so you could end up having two appraisals that are done by a certified real estate appraiser, and then you can ask your real estate agent to do a market analysis and to see where those values come in and if they're close to the different appraisals that have been done. And so there's other ways that you can, and other, there are other professionals that we do lean on and gather information from, albeit again, may not be accredited as an expert at a trial, but have a lot of really helpful information that we can use as markers when looking at values.
And if we're staying on the topic of residential or even commercial real estate, mortgage brokers tend to be people that we and our clients rely on pretty routinely for a few different purposes. One, if we're transitioning a property from both parties to one party, so we're not selling it, but we're giving it to one party on the balance sheet, the party who's getting off that title and the mortgage on that property needs it to be refinanced so that they can get off it. So we're often dealing with a mortgage expert to come in and give us an idea. Can they refinance the person off that wants to get off the mortgage? What is the rate going to look like, so that we can project the cost on a monthly basis to the party who's staying there? So that's another person that is going to get engaged pretty frequently to assist us.
Great. So what I'm hearing is the divorce lawyers, again, as I keep doing these podcasts, very strategic in your approach. Never wing anything, obviously. You bring in the appropriate experts as needed by their specialty. And that's why the attorneys at Beermann get excellent results, because you all know what you're doing.
We wear a lot of hats, and we didn't even cover all the different people that we typically will get involved with. But, there are other experts as far as children that we do engage from time to time, whether they be court appointed or not, to do valuations for custody purposes, therapists that help us out with child-related issues frequently, varying types, whether they're occupational therapists or just pediatric therapists. And I know Jessica and I had talked about mediation, so mediators versus arbitrators. I don't know if you want to just really briefly hit that.
Right. So we use, as often as we can in the appropriate circumstances, mediators to mediate a case. A lot of times clients will come in and say, I want to do arbitration. and you have to explain, well, there's a difference between mediation and arbitration. Mediation, third party, there to facilitate communication between the parties to hopefully create a amicable resolution. Arbitration is similar to court, but you're not in court, such that that third party makes a decision. Instead of a mediator who's, again, there to facilitate communication, the arbitrator makes a decision for you after presenting the different evidence from both parties. So again, lots of people, lots of experts. We have a very long list of people that we use and use often who are have helped us create wonderful results.
Excellent. Well, thank you so much for your time. This has been interesting and enlightening as always. Again, if you liked this podcast, please subscribe to our podcast channel. Please like us on Facebook and LinkedIn, where you can always stay abreast of all the latest podcasts. As I mentioned before, this isn't the last that you've seen of Tom or Jessica. They'll be back speaking about another divorce topic. So until then, thank you.
Thanks for joining us on this episode of Divorce Talk. Visit our website at www.beermannlaw.com, where you can subscribe to the show so you'll never have to miss a single one. Please also follow us on Facebook and LinkedIn and subscribe to our YouTube channel. If you found value in this show, we'd appreciate a rating. Be sure to tune in next time for another enlightening episode.